Good day to you and welcome to another Paddocks Club video tutorial. Today, as you see, we're going to have a quick look at Prescribed Management Rule 64. It is one that we often talk about but don't often examine in detail. Let's just go through the wording. Except in cases where a special resolution or a unanimous resolution is required under the Act, an owner shall not be entitled to vote at any general meeting if A. Any contribution payable by him in respect of his section and his undivided share in the common property have not been duly paid, or B. He persisted in the breach of any of the conduct rules referred to in section 35(2)(b) of the Act, notwithstanding written warning by the trustees or the managing agent to refrain from breaching such rule. And then there's a proviso, provided that any mortgagee shall be entitled to vote as such owner's proxy at a general meeting, even though paragraph A of the aforegoing provisions of this paragraph may apply to that owner. So what do we conclude? Firstly, this provision does not apply to trustee meetings. Clearly, it's only general meetings, meetings of owners, to which the voting suspension can apply. And it also does not apply to special or unanimous resolutions, only to ordinary resolutions. And it doesn't apply to situations where bondholders act under mortgage bonds as proxies for owners in levy arrears. The first ground of suspension of an owner's voting rights is failure to pay a levy that is due. So what does the word contributions mean in this context? Well, the Act uses contributions, the word contributions, rather than the word levy. It talks about levying contributions, and we talk generally about levies. But this is a levy they talk of. So they mean levies, special or general. But they don't mean other claims by the body corporate against an owner. This thing is limited to levies being in arrear and unpaid. The second ground of suspension of an owner's voting rights is persistent breach of a conduct rule, despite written warning by trustees or managing agent. So what does persistent mean? Well, normally that'll mean an ongoing, repeated or regular breach. He's got the warning, he or she still carries on with the same behavior. Is this just in regard to the scheme's conduct rules? Yes. You can only apply it if the person is arguably in breach of one of that scheme's conduct rules. And what qualifies as a written warning? Well, a letter, an email, something that gets there, and sometimes something you know has been received. You can't you can't simply send something into the ether and then assume it's been received. So if it's been sent to the owner's domicilium or delivered to the occupier at the actual section address, then you can be sure. Otherwise, of course, you can't. So what would examples be of conduct rules? Well, typically the pets would be the most usual one, but I think also unauthorized changes to common property are probably going to come up in this sphere. The bondholder's right to act as a defaulting owner's proxy only applies when levies are in arrears. Remember, that was a reference only to A, not when the owner is in persistent breach of a conduct rule. And what other issues apply? Well, some people say, well, if you can't vote, you can't come to the meeting. Well, no, that's not true. You can't be counted for the quorum for the meeting if you can't vote, but you certainly can attend, and you certainly can speak at the full meeting. So what if the owner disputes the validity of their levy? That can be difficult. I mean, if the trustees need to make absolutely sure that that special levy, for example, was properly raised, and if it's not, then they have to be very careful about trying to impose a voting suspension at a meeting. What if the owner says that he has or she has paid? This was a matter that was raised in the discussion forum. They turn up at the meeting and say, I put in your bank yesterday, or here's a check. The short answer is, until it's in the body corporate's account, it's not paid. It may be promised, but it's not actually paid. And what if the owner tenders payment at the meeting? Well, in fact, I've just touched on that. A tender of payment is not actual payment. I hope that this has been of assistance to you, and please invite you to discuss any matters arising in the discussion forum.